Thank you, Mr. Speaker. Members, the purpose of this amendment is to ensure that the funds appropriated to the Attorney General's office are not used to appeal the U.S. Western District Court's decision in the Perez versus Abbott case. As you know, on March 10th, the majority of a three-judge federal panel determined that 3 congressional districts drawn by this legislature were discriminatory and minority voting strength had been diluted.
Stand chair for what purpose?
Mr. Speaker, would the gentleman yield?
Gentleman yield.
I'd be happy to yield.
So, thank you, Chairman, for bringing this amendment. Am I correct that the current redistricting cases pending here in Texas involve claims by Texas citizens that their rights, their voting rights specifically, are being violated under the U.S. Constitution and the Voting Rights Act?
Yes, Representative Anchia, that's correct. The State House, State Senate, and congressional boundaries were all challenged after being redrawn in 2011 by both Hispanic and African American Texans, claiming that violations of the Constitution and the Voting Rights Act had occurred. All 3 maps at various times have been ruled by the federal courts to violate both the Voting Rights Act and the United States Constitution. Now, the voting rights claims against the Senate map were settled after the state was forced to remove the discriminatory features a few years ago. And while the House and congressional plans were slightly reconfigured by the legislature in 2013, our state leadership failed to make the significant changes needed to remove voting rights violations, so legal claims against the state have persisted and continue to this day. Late last month, the 3-judge federal court with jurisdiction over the case again ruled that the congressional plan drawn in 2011 violates the voting rights of minority Texans and confirmed that many of these illegal features persist in the current map that we're under today. And we're expecting a similar ruling to be issued by the court very soon on the State House map, as you know. And if the Attorney General continues to relentlessly resist this ruling, file appeals and other motions that drag out the litigation, our citizens will be the ones that continue to bear the burden of the high court costs. Moreover, millions of Texas citizens will continue to have their voting rights violated.
Mr. Chairman, am I also correct that in the most recent court ruling related to the congressional map that you just alluded to, the court found that not only did the congressional plan have a discriminatory effect against Hispanic and African American Texans, but the plan was adopted by the legislature with an intent to discriminate?
Yes, unfortunately, that's exactly right. The court found violations of the federal voting rights law in several parts of the state and then reinforced the severity of those violations by ruling that they were the result of an intentional effort to undermine the voting rights of minority Texans. In fact, the recent ruling on the congressional redistricting plan marks at least the fourth time that a federal court has ruled that a redistricting plan or a voter ID law adopted by the Texas legislature and signed by the governor since just 2011, the last 6 years, 4 times, has intentionally violated the voting rights of Texas citizens. And it is quite possible, after we see a ruling from the court on the State House map, that we'll have 5 of those shameful rulings. Sadly, no other state in the nation has been found by the courts to have intentionally discriminated against the voting rights of its citizens over the last 5 years than Texas. We have been the worst of the worst, unfortunately.
Thank you for raising that, Mr. Chairman. And just so I understand what your amendment does, it seeks to withhold funds from the Attorney General to file and pursue appeals against adverse rulings by federal courts in redistricting. Now, given that the courts, as you correctly pointed out, have consistently ruled that redistricting plans violate both in effect and intent the voting rights of Hispanic and African American Texans, isn't it true that appeals filed by the Attorney General and other legal maneuvers to resist the rulings by these courts amount to use of state funds to protect and perpetuate not only discriminatory effect but discriminatory intent against Texas citizens who the AG has a duty to protect?
You're exactly right. And this is the exact purpose of my amendment. For more than 5 years now, the State Attorney General's office, under 2 Attorney Generals, former General Abbott, current General Paxton, have expended millions of taxpayer dollars to protect and defend redistricting laws and voter ID laws that courts have ruled violate the basic voting rights of Texas citizens under the Constitution and the Voting Rights Act. Even court findings of intentional discrimination have not been enough to convince this Attorney General to drop his appeals and end his defense of these discriminatory laws. The legislature, unfortunately, already bears the scars of these federal rulings of intentional discrimination. A yes vote on this amendment is an action to begin healing those wounds and perhaps begin to fade those scars from past actions. Conversely, I want to make sure members understand what a no vote means. It worsens those wounds and reinforces the mistakes of the past. Make no mistake, a no vote on this amendment will signal to the Attorney General that he has the approval of this legislature and support of our State House to continue to defend discriminatory laws that hurt millions of Texans, of our constituents.
And we're not talking about trivial matters here related to a budget. We are talking about fundamental voting rights that are the cornerstone of our democracy. And we are still arguing in court about illegal maps that were adopted originally in 2011, and today it's 2017. Is that not correct?
That's exactly right now. We are 6 years into this decade. It's more than half over, and we are operating under maps that have been found to be intentionally discriminatory to African American and Hispanic voters across the state of Texas. It's time that this legislature take action and say we are no longer going to tolerate this, and we need to correct the wrongs of the past.
Thank you, Mr. Chairman.
Thank you, Chairman Anchia. I move adoption.
Chair recognizes Mr. Phillips.
Thank you, members. I move to oppose this bill and to quickly move to table. The amendment. I voted for those maps. I didn't intend to discriminate. I want the Attorney General to still fight for those of us that felt like we were doing the right thing for Texas under the Constitution, under the law, and join me in showing that we did not discriminate. We didn't intend to. I disavow that. Did anybody here intend to discriminate against minorities when we voted that? That's what we were just told. They were saying that we intentionally did that. We had intent to do that. I reject that. And I want the Constitution, I want the Attorney General to continue to fight for that.
For a question?
Mr. Navarez, what purpose?
Yes, I will.
For a question.
Does the gentleman yield? He yield.
Larry, do I have to bring the emails that the federal judge perused to come to a ruling so we can talk about what the intent was by the authors and the people working on the bill? I'm not speaking to you specifically, but if you want to make a general accusation or a general charge about what discrimination is and isn't with respect to this litigation, if we need to pour over and get these emails and then talk about this amendment more, we can bring them down here and we can put them up here, Exhibit A, Exhibit B, Exhibit C, regarding intent to discriminate. Do we need to do that?
You can do whatever you want to, Representative Navarez. There was no intent by me to do that, and I don't think of the other good people of this body.
Mr. Speaker.
Mr. Anchia, for what purpose?
Will the gentleman yield for questions?
Yes, I will.
Representative Phillips, I want to make sure I understood you correctly when you suggested that this body was being told that there was intentional discrimination. What you were really talking about are the federal judges that were both appointed by a Republican and a Democratic president, right? Because they're the ones who issued the ruling.
I'm not going to get into the debate about the judges or what they did or didn't do. I just said that's what y'all were saying, and I clearly am not going to, and I don't want to say that we shouldn't have our attorney generals stand up and do their job, which is to defend the Constitution.
Do you deny that a Republican appointee and a Democrat appointee said that there was intentional effect and intent in the drawing of the maps? Again, this is not Chairman Turner and me saying this.
Okay, let me finish
the question, because to lay the proper predicate, we were not telling this body that there was discrimination. We were simply articulating what now 4 courts have said about the Texas legislature, Republican and Democratic appointees. So I want to make sure that when you're talking about you were being told, you also mentioned that you were being told by federal courts.
What the courts said speak for themselves in the opinions. So they say what they say. I'm telling you, I want the Attorney General to continue to fight for what I believe was the truth, is there was not that intent, certainly not by me and certainly not by the good people I know that voted for that bill on this floor.
So
we can debate that issue. It's not a partisan issue, and that's what we're continuing to make it. This was an
I
issue.
agree that
This
it
was
is
an
not
issue that we voted
partisan,
for. So.
because Malk is a bipartisan organization with successful plaintiffs in that litigation, and both a Republican and a Democratic appointee have made that point. So I just want to say, we're not telling you anything other than reporting on what federal courts have said, and I hope you would acknowledge that. And if you disagree with the federal courts, that's fine. And in fact, do you disagree with them? I imagine you do.
No. Well, let me just say this, Mr. Anchia.
Yes.
So we don't continue this on. We've got a long night.
Yep.
I believe that the Attorney General has a constitutional duty to defend what we pass, and I just want to continue to fund that. That's it.
Okay. Do you not agree that the Attorney General has a constitutional duty to protect the voting rights of Texans? Is that not his constitutional duty? Or is it simply to protect the discriminatory intent of the legislature as articulated by the federal judges?
Mr. Anchia, I just moved to table. Can we have the vote?
Okay.
Chair recognizes Mr. Turner to close on his amendment.
Thank you, Mr. Speaker. Members, I appreciate the time we've spent on this, but this is a serious issue. As Representative Anchia said a minute ago, there is nothing more fundamental than people's basic voting rights. And this legislature, unfortunately, has passed laws that have been found 4 times in the last 6 years to be intentionally discriminatory against minority voters. And we're expecting to have a 5th such ruling here probably in a matter of weeks. And this can't continue. This is not acceptable. It is not acceptable to draw maps intentionally designed to crack and pack minority voters, splitting up minority voters to dilute their voting strength, packing them into districts to condense their voting strength. If this legislature is serious about what members say, that we have no intent to discriminate, that we have no desire to disenfranchise anyone, then we will send a strong message to the Attorney General that we want to discontinue this ongoing fight in federal courts.
Will the gentleman yield for just a couple of questions?
Yes.
He yields.
Thank you, Mr. Speaker. Chairman Turner, I heard Representative Phillips say that it is the Attorney General's constitutional duty to defend the discriminatory actions of the House. Do you agree that that is the constitutional duty of the Attorney General?
No, I believe the constitutional duty of the Attorney General is to defend the Constitution, first and foremost. And when you have laws that violate the Constitution, it would seem like you would no longer defend those laws. And
in defending the Constitution, when you have federal court rulings, again, this is not you and me saying this. This is 4 federal courts now that have found either discriminatory effect or discriminatory intent in the actions of this legislature. Is it not, which have ruled the maps that we currently operate under unconstitutional, and we're talking U.S. Constitution, do you not believe that it is the duty of the Attorney General, in fact, to follow the Constitution and follow the dictates of the federal courts?
I believe absolutely it is. I think our Attorney General, as the chief law enforcement officer of the state, should be the one to tell us when our laws are in danger of violating the Constitution, especially after 4 courts in this case, have found those laws to be intentionally discriminatory. That Attorney General should cease to defend discriminatory laws, and that's all this amendment would do.
And Representative Dukes was reminding me that, oftentimes we think about intentional discrimination and we think that's all in old-timey black and white film, that we might see on the movie channel or in documentaries from a long, long time ago. But this is happening real time. These are contemporary actions, are they not?
They are, unfortunately. This is not, unfortunately, some remnant from the 1950s or 1960s. This has happened in this decade, in the 21st century, laws that have been consistently found to intentionally discriminate against minority Texans.
Thank you so much.
Thank you.
Ms. Dukes, for what purpose?
Will the gentleman yield?
Does the gentleman yield?
Yes, I do.
He yields.
Chairman Turner, on the issue of the Attorney General representing the decision of this legislative body on a matter that the federal courts have determined as intentionally discriminatory. When has it been that an entity, a state, a locale, has been aware that they truly, intentionally were discriminating, especially when, let's say, we consider the University of Texas and its proclivity at the time for preventing African Americans from attending the University of Texas School of Law? Did this legislative body, the ones who were here then, understand that they were discriminating?
It's a great point, Representative Dukes, and it's another unfortunate, shameful episode from our state's past. I'm not advised if any members were here that are presently here were in the legislature at that time. But I think to that point, it took a federal court to desegregate the University of Texas School of Law. It wasn't elected officials who did it or Board of Regents who did it. It was a federal court, just like in Brown versus Board of Education and other significant court rulings in our past. And the same is here too. A federal court has had to step in and enforce the law and enforce the Constitution against maps that it has found to be intentionally discriminatory and a violation of the Constitution and the Voting Rights Act.
Are you aware that when the courts ruled in Sweat versus Painter that this legislative body, instead of allowing African Americans to attend the University of Texas, they put a library on East 12th Street here in Austin? Little bitty library in the basement of a home where the African Americans were to, per se, attend law school.
I do recall that episode, Representative Dukes, and it's a shameful and sad vestige of the separate but equal doctrine that this country operated under for far too many years, because we know that separate is not equal.
Correct. Separate is not equal. And that is part of the reason that we have Texas Southern, part of the reason that we have PV, was because this legislative body did not realize how much it was discriminating, yet the courts were trying their best to indicate so. Wouldn't you agree that maybe it's time that we agree with the courts, with their indication that intentional discrimination perhaps did exist in the plan based on the techniques that were utilized, not what was in the heart of anyone who voted, but in the techniques, the mechanics of Red Apple?
Absolutely, and I think that through multiple court proceedings and trials, the evidence showed that. As Representative Navarro spoke to earlier, the emails and other documents showed that intent to discriminate.
Mr. Dutton, for what purpose?
To ask a gentleman a question.
Gentleman yield?
Yes.
He yield.
Are you aware of the difference between direct evidence and indirect evidence?
I'm not an attorney, as you are, Representative Chairman Dutton, so I won't try to explain legal terms.
The only reason I ask is because generally when to prove intent, we prove intent usually with something other than direct evidence, because nobody ever admits intent, particularly when it comes to things like intent to discriminate. And so that's why
Representative Hefner calls a point of order. The gentleman's time's expired. Point of order is
thank you.
respectfully sustained.
Thank you, Mr. Speaker. Members, please vote no on the motion to table.
Mr. Turner offers up an amendment. Mr. Phillips makes the motion to the table. The question occurs on the motion to table. Record vote. The clerk will ring the bell. Show Mr. Turner voting no. Dr. Zerwas voting aye. Mr. Longoria voting no. Have all voted? Being 90 ayes, 55 nays, the motion to table prevails.